Number 109079, Kane v. Jaycox.
May it please the court, I'm David Troop, and I represent the plaintiff and appellant in this matter, Denitra Kane. I'd like to request 3 minutes for rebuttal, if I may, Your Honor.
3 minutes is granted.
The facts in this case are not in dispute. It involves whether the plaintiff will be entitled to recover interest for the many years that the defendant did not pay child support while he was making $2 million a year playing for the San Diego Chargers and the New Orleans Saints. There are 3 matters I think of particular importance. No one claims that the amount that was collected from Mr. Jaycox as a result of the Texas proceedings included any interest that had accrued under Kansas law. They don't claim that. The Court of Appeals, I think, either expressly or certainly impliedly agreed that money, as he has not had to pay that thus far, and if the Court of Appeals is upheld, he won't. Second, the Kansas child support order was forwarded to Texas for enforcement only without any authority for Texas to modify the order, and I don't think anyone questions that either.
And that order that stemmed from Kansas that went to Texas,
yes,
included not only the back support but also the interest that had accrued. Is that right?
Well, the interest, that's under the Dallas case from this court. The interest, you don't have to do anything to ask for interest on a judgment. It's automatic. And in support cases, the law is that the interest starts accruing from the day each judgment is entered, usually the first day of the month in 99% of cases.
But what the initial Kansas order, or the obligation that was sent to Texas to enforce, didn't it include a calculation for interest?
It did not. No.
It did not.
And the reason for that is KAR 30-44-5, which is the regulation that says when a child support obligee requests services of what was then SRS, now DCF, the Child Support Enforcement Office, that does not include collection of interest unless the court has liquidated that sum and determined that. What CSE could have done is file a motion in Riley County District Court, said, we've got 7 or 8 years of arrearage here, we need you to determine the interest. That regulation says we don't have to do that.
Okay, and that never occurred.
So that never occurred.
Went to Texas.
So
okay.
Basically what they sent to Texas is a ledger that shows here's the dates that support accrued, here's the amounts of payments, and the total support accrued, not counting interest, was $200 and some thousand. The amount paid, $100 and some. The difference was, I think, 132 or thereabouts. And then the third issue that I think no one disputes is that Kansas, under both UFSA and the federal law, was the state that had continuing exclusive jurisdiction. 2 of the issues, because of those 3 factors, 2 of the 4 issues we raised in our supplemental brief are fairly easily resolved at the outset. FICASOA, I guess, would be the shorthand, the Federal Full Faith and Credit for Child Support Orders Act, FFCCSOA, does not require or permit that the Kansas District Court give full faith and credit to the Texas judgment, even though that's what Judge Wilson and the Court of Appeals did here. Subsection E of 28 U.S.C. 1738b specifically says Texas cannot modify the Kansas order. Even if the Texas order is considered a child support order, and I don't think it is under the federal law, but even if you give it a broad construction, subsection F2 of that statute specifies that it is the Kansas order that must be recognized. Thus, the Court of Appeals, I believe, was clearly wrong in holding that the federal law requires the Kansas court to give full faith and credit to the Texas order. The second issue of our four issues that I think is resolved by those three factors is the Court of Appeals ruling on Summit, that Summit doesn't apply to this case. In the Summit reading at the bottom of page 817 and 31 Canap 2nd, the court specifically held, with the enactment and adoption of UIFSA, the North Carolina court no longer had jurisdiction to vacate the Kansas orders. Skipping a couple of sentences, accordingly, Kansas maintained a continuing exclusive jurisdiction over its child support orders, rendering North Carolina without jurisdiction to nullify them.
Counsel, even if you're correct on those 2 points, if you're correct that the Court of Appeals in its ruling was wrong in its discussion of Summit and in its discussion at the very end of its opinion on the full faith and credit clause, how does that lead to you prevailing in this case? In other words, those weren't the primary holdings, even if they even were holdings at the Court of Appeals level or at the district court level. The court held that your client's claim was barred by res judicata, correct?
Yes. If Summit is good law, the Court of Appeals has to be reversed. This case is Summit. The facts are virtually identical, except in Summit you had the North Carolina, well, they really are identical. In Summit you had a Kansas judgment, goes to North Carolina to enforce it, and the North Carolina court says, sorry, there's no arrears to enforce. We determined there's no arrears. Comes back to Kansas, and the obligor, who is in North Carolina, says, hey, North Carolina says I don't owe anything, res judicata, and Kansas Court of Appeals says, no, you're wrong, res judicata doesn't apply under UIFSA because what North Carolina says about how much you owe, we don't have to abide by. It's exactly the same thing here. The only difference here is the Texas court here was maybe misled or given incomplete information.
Doesn't this all come back to whether or not the Texas court modified the Kansas order?
Both the appellant, or both the appellee and the Court of Appeals made a big deal out of the argument that, well, the Texas court never expressed any intent to modify the Kansas order. And I agree with that. I don't think the Texas court intended to. The problem is the Riley County District Court and the Court of Appeals have given the Texas court that authority. That's the way they have read the Texas judgment or the Texas order, is they have determined that the Texas court modified the Kansas judgment by completely satisfying it, even though there was more money owed under the Kansas judgment than the Texas court determined there was.
Couldn't the Texas court have made a finding under Kansas law as to the interest owed?
Yes.
And couldn't that issue have been presented to the Texas court?
I think it probably could have been presented. It could not have been presented by Denitra because she tried. She wasn't a party to the action. She asked the Texas authorities, he went a long time without paying, I should get interest under Kansas law. And the judge there said, go back to Kansas and have the Kansas judge tell us how much interest and then bring it back and we'll enforce it. So Texas made the determination that we are going to rely upon what Kansas told us, because the paperwork that came from Kansas said incorrectly, based upon that regulation, there is no interest owed. That was a misstatement of Kansas law when CSE sent this. But Ms. Kane had nothing to do. She didn't have any control over that, other than, I suppose, Child Support Enforcement could have told her, by the way, our regulations don't allow us to collect interest, so go out and hire your own attorney if that's what you want to do. They didn't tell her that. They don't tell their clients or the people that they're enforcing obligations for the limited nature of the services that they can provide. So yes, the Texas court, I think, under their version of UIFSA, could have gone back and said, okay, we'll do what Kansas wouldn't. Kansas refused to determine how much interest is on it. We're going to enforce the Kansas judgment, so we'll go ahead and do the math. I can absolutely understand why Texas did not feel obliged to do that. They may have felt, well, if Kansas Child Support Enforcement doesn't care enough about this, why should we? So the issue then, and again, I think unless you're prepared to overrule Summit, you've got to reverse the Court of Appeals here because they are the same case. Res judicata was raised in Summit, would have been a viable defense in Summit if the court held that North Carolina court had the jurisdiction to modify the Kansas order. And that's
just
exactly what...
On that point, and this is for my own sort of clarification in my mind, as I understand your argument, it is that because the Texas court modified the Kansas judgment, it's undisputed that the court would not have had jurisdiction to do that, to enter into a modification.
Correct.
And because of that, it's not an order from which the defendant can claim res judicata
Yes.
or preclusion. That's your
Yes.
argument. And so it hinges on this question of modification.
Yeah, I don't think there's any doubt that given the construction that the Riley County District Court and the Court of Appeals placed upon the effect of the Texas order, wasn't a judgment, it was an order, that they found that in fact it modified the Kansas order. I think that would come as a surprise to the Texas court because I don't think they intended to. They did what they were asked to do.
What bearing does the fact that you claim she was not a party to the Texas action have on res judicata?
Well, because there's four factors in res judicata. The first is whether it's the same claim, and my contention there is that an action that is limited to enforcement of an existing judgment is a different claim than an action to actually establish a judgment. The second requirement is that it has the same parties.
Well, but and so you're claiming that the Texas action did not have the same parties as are involved in the current Kansas proceeding.
Correct. Ms. Kane was not.
And so then I wanted to clarify, because I understood you to answer Justice Stegall that the modification issue was the sole determinant of res judicata. What I'm hearing you say now is that it also wouldn't apply because they're not the same parties.
Oh, okay. And if I said it was the sole thing, then I misspoke. No, I didn't mean that.
Okay.
No, they're not the same parties, and the reason for having the same party requirement in res judicata is that it's somehow considered unfair that you already had a bite at the apple, you don't get a second bite at the apple. She didn't, because she had no power to control. She tried to. She tried to ask for interest in Texas. She didn't have any, she was not a party to it. She was a witness, she was there. The Texas Attorney General Child Support Enforcement people, they were the people that were enforcing this judgment, and they were the plaintiff in that action, in the Texas action. Number 3 requirement for res judicata is whether the claim could have been raised, and I think they're going back to what I said to Justice Stegall. I think under the UFSA, it probably could have been raised by the Texas Attorney General. It could not have been raised by, at least they determined it couldn't be raised, by Ms. Kane. She urged them to, she begged them to, and she was turned down, and she didn't have the standing. Now, could she have hired private counsel in Texas and entered an appearance as a formal party? I assume yes. I don't know that. I haven't specifically checked the Texas procedure rules, but I assume that she could have done that. But she didn't, and she wasn't informed that that's what she should have done. And then the other question, the fourth element of res judicata, was it a final judgment on the merits? And then that begs the question of whether the Texas court had the authority to change the amount that was actually owed, or basically forgive the interest. The Bartlett decision in Alaska that I've discussed in my brief, I think, addresses that issue. And in Bartlett, while it involved collateral estoppel, they're closely related. There you had Alaska and Arizona. Arizona had determined in the enforcement proceeding that there wasn't jurisdiction over the obligor. Went back to Alaska and he raised that as he raised the res judicata or collateral estoppel in Alaska, and they quoted from the restatement of judgments that there's a difference in the nature and quality of the type of proceeding in the very limited type of proceeding where you have a responding state under U.S. And so it would not be entitled to the same enforcement or the same deference as a actual final judgment on the same case. So at least two and perhaps three of the elements for res judicata were not present here. But should you find that they were, then I think the issue that's squarely presented is whether this court should follow the lead of the Georgia court in Dial versus Adkins and find that where you're talking about the best interests of the children or best interests of the child, that you can relax these strict rules of res judicata as we do in child custody. Court of Appeals raised this and basically backed off from it and said, that's not our job, that's not, our Supreme Court hasn't gone that far. They did it for custody in Hill versus Hill, but they haven't done it in child support. Both types of cases, you're talking about the best interest of the child. Should the child, in this case, be financially punished because of a strict application of a rule to circumstances that it probably wasn't really created to address? Jay Cox is not a good candidate for sympathy here. He was making $2 million a year and went 7 or 8 years without paying child support. And I don't think he's the type of guy that you want to really extend a procedure to apply to. I'd like to quote from the Mississippi Supreme Court. It's a fairly old case, 1986. The use of one's money by another has value in economic theory and in fact. In our society, this use frequently is compensated by the charging of interest, such charges being imposed variously under the authority of public and privately made law. The economic value of a supporting spouse's use of a child's money or forbearance to pay for whatever reason is real and should be compensated via interest. When a supporting spouse fails timely to make child support payments, he uses the child's money. That's what's happened here. Mr. Jay Cox so far has been allowed to get an interest-free loan.
Counsel, you're out of time, but can I follow up with one? So you're arguing that under Kansas law, this Texas judgment actually does include interest.
I'm sorry?
It sounds like you're saying that applying Kansas law, this Texas judgment actually does include interest, effectively, if we apply Kansas law.
No. Clearly, no one claims that the amount determined to be owed by Texas included the interest that Kansas requires.
It doesn't in the judgment, but your argument is that Kansas law essentially bootstraps interest on as a matter of law.
Yes.
Okay.
Yes. And that, basically what you had is the paperwork wasn't complete, the paperwork that was sent by Kansas to Texas. So you actually had, and we don't have an agreement on the amount, but you actually had a judgment that at the time it was sent down there was $180,000. Kansas told Texas it was only $130,000. Does that mean that $50,000 just vanishes, that the plaintiff doesn't get it as a result of the Kansas administrative reg that she didn't know anything about? So we would ask that the court reverse this decision, send it back to the district court to determine to do the math and determine the amount of the child support that is yet unpaid.
Thank you, counsel.
Thank you, Your Honor.
May it please the court, I'm Blake Johnson, appearing on behalf of the appellee, Kendall Jaycox. And I'm asking that you affirm the Court of Appeals ruling and hold that res judicata does bar further litigation of this issue, specifically regarding this unpaid child support. I think the first main issue to discuss is this underlying question of whether or not this amounts to a modification. And I think one way to look at this issue is, does any time an amount paid veer from the expressly defined amount of the judgment, does that amount to a modification? And I think that's clearly not the case. That's why we have a principle of settlement and negotiation within the courts. And it's, so for example, in a case like this, and, I would also point out that all parties stipulated to not bring up these factual issues. And there are a certain number of facts that are kind of bleeding into this discussion right now that were never cross-examined and that were never evaluated. And so, speaking purely hypothetically, let's suppose that there was a situation like this where you have unpaid child support. Now, let's suppose over the course of that period, the person required to pay the child support was paying for the child's private schooling. And through procedural negligence on both parties' part, that was never included in the actual child support order. Now, there's a lot of law that says whether or not you can be credited for that, etc. But it's perfectly reasonable for parties in front of a tribunal to say, all right, we know there's an issue of whether or not you can receive credit for paying for somebody's private schooling. We know there's an issue of arrearages. We know there's an issue of interest on arrearages. We're going to settle all matters for one lump sum payment, end it right now. The person receiving child support walks away with a large sum of money. The person, paying has then, doesn't have to face future litigation on both sides.
But Counselor, that's all the parties together. In this
Yes.
instance, the wife was not in the court to say, I take this.
With all due respect, Your Honor, that's incorrect. She was present. She was a pro se litigant. She signed the final judgment as a pro se litigant. As the Court of Appeals pointed out, she went down to Texas 6 or 7 times and appeared in person in front of the court to hear all of these matters. She was there. And as to the issue of res judicata, that second element, which is the parties, there was some discussion of a case that called Hartman, and I believe it came up in the Court of Appeals case, or the Court of Appeals ruling, which essentially set the standard that, as long as the party is notified and present, that constitutes, that they're there for the purpose of res judicata. And also the cases that were found that, that showed that an agency collecting child support on behalf of someone, res judicata didn't apply. That was when those agencies were specifically going for public funds that they had expended. So if SRS had just said, we just want back all the funds that we've given to the child support recipient and nothing more, then there would be an argument present that the same parties weren't there. What happened, though, is SRS forwarded the entire schedule of child support payment, the amount owed, the order. So it's sort of misleading to think that they sent down this judgment to Texas that said, hey, you owe $130,000 or whatever it was. What they sent down to Texas was, here's the child support order. It's X amount of dollars per month. These are the number of months that it hasn't been paid. And this is important because UIFSA specifically empowers the Texas court to apply Kansas law in that situation. And, within UIFSA 6-604, it specifically says that they have the authority to calculate interest. So Texas has the complete schedule of child support payments, the complete schedule of how much it was, how much was missed, and the authority to apply Kansas law to collect interest.
Well, counsel, if I could interrupt you and just ask, assuming all of that is true, what is someone like Ms. Kane supposed to do when a court like the Texas court says, you have to go back to Kansas and do that? We're not going to do that.
I would
What is
say
she
two
supposed
things.
to do? What is the recourse?
I would say two things on that point, Your Honor. One is that I don't think that happened, and also that goes out. There was never a fact-finding procedure on that to determine whether or not that happened. And second, they can appeal in Texas. She has the full ability to go to the Texas court and say, you made an error, and appeal within that context. I mean, this raises the question of, so under UIFSA, as a signatory, Kansas has entrusted Texas with the ability to apply our law. And if we didn't trust Texas to do that, we should not be a member of the UIFSA structure. And so within that context, she needs to, Texas is the state that determines whether or not Texas made any errors in their judgment. And this raises the possibility that every order entered in every other state is now subject to return to Kansas and say, well, did they do it correctly? And it can be done for any reason, because as in this case, we haven't, and it was a strategic decision, I assume, on both parties' parts, not to delve into these facts, largely because all the facts are in Texas, and we would have to get transcripts, try to find witnesses in the hearing in Texas, and that was, difficult process to go through. And if the standard is anytime another state under UIFSA arrives at a different number than the other party believes is accurate, now you're subject to an entire review over the whole process, and there appears to be no standard for that. The Court of Appeals found res judicata applied, even assuming that there was an error in Texas, which I think would be the worst case scenario for my client under a factual finding, that Texas was just negligent somehow. I think even under that situation, Texas is the state that needs to determine whether or not an error applied. But, and I tried to bring this out a little bit in my brief, and again, I tread carefully because we did decide not to go through the whole factual scenario, but there are other reasons why that judgment is the number it is, none of which constitute a modification and none of which constitute any error on behalf of Texas. And that's where the principle of comity applies, where, there's no reason for us to assume that Texas did anything inappropriate. There's nothing on the face of any of the orders that say any mistake was made. And if we're just of the position that at any point, any order done in any state under UIFSA can be brought back to Kansas for a retry, as the Court of Appeals pointed out, now you're back to this situation of competing orders that was one of the reasons that URESA was ultimately abandoned. And so that goes back to this issue of the Summit case, which I think the Court of Appeals rightly saw as not being applicable here. What was going on in Summit was this situation where North Carolina and Kansas were just disagreeing about what the order was. There were these competing orders, and ultimately UIFSA only comes in at the very end, where the last time they tried to enter this order in North Carolina and North Carolina vacated it, that was under the UIFSA structure. Now, the reason res judicata didn't apply in that situation was this unique sort of situation in North Carolina about how you technically vacate an order under North Carolina law. And there's no reason to suppose that any ruling here in this case would have any role to play in res judicata in that specific technical circumstance, especially if you don't find there was a modification that took place, which again, just arriving at a settlement judgment, which again, this final judgment was signed by Ms. Kane as a pro se litigant after 6 or 7 in-person hearings. So Summit in no way binds this court to any particular decision on this res judicata issue.
I'm having trouble
Yes.
understanding why the Texas order isn't a modification if it's in fact some sort of settlement or compromise or handshake that this is the amount owed.
I don't think that's a statement of this is the amount owed. I think it's a statement of this is the amount that I will accept in order to end any future litigation on the claim. And again,
That's got to be a modification of what the claim was up in Kansas.
well, maybe
Or what arises from the claim in Kansas.
Yes, I understand, Your Honor. So maybe, and again, this may be a semantic issue. This may be an issue of what we're calling a settlement, what we're calling a modification. Perhaps this is a better way to think about it. Because UIFSA empowers Texas to arrive, to basically use Kansas law to arrive at their decision. The question is this Was that final judgment a judgment that could have been arrived at if this took place in a Kansas court? And I think most certainly that's the case. Whether you call it a modification or whether you call it a settlement, if this had been in front of Judge Wilson in Riley County, the exact same amount of judgment could have been used to settle all future matters. And if Kansas could arrive at that decision, UIFSA certainly empowers Texas to arrive at that decision. And again, in that situation, had it gone on in Kansas, I think it's pretty clear that there could be no further, if there was a judgment signed by all parties to the issue that said this is what I'm accepting, as an amount based on this specific schedule of unpaid child support, if Kansas could arrive at that conclusion, Texas could arrive at that conclusion. In Kansas, I think res judicata would certainly apply. I'm not sure there's been any disagreement about that. So then I think it also has to apply in Texas. Again, and I think in many ways, a lot of the cases that we've sort of come up with along the way have kind of clouded the issue, which is an actually, rare as it may be, a fairly clear statutory framework that explains, exactly what these states are empowered to do, and the states both obeyed them fairly accurately. It's only later that this issue came up of whether or not somebody was satisfied with that judgment that Texas arrived at.
Let me make sure I'm clear on this.
Yes, Your Honor.
The Kansas court, I'm just going to make up numbers.
Sure.
The Kansas court said that as of a particular date, you owe $150,000. And you go to Texas, and the Texas court enters an order that says, as of that date, you owe $100,000. That becomes the number as of that date, and you're done.
And again, I think there's a slight.
Right. I mean, I'm just trying to say, excuse me. You're saying the Texas court was empowered to reduce the amount of a Kansas judgment by our hypothetical numbers.
Maybe or maybe not. I think for certain what they're empowered to do is if the parties arrive at a negotiated settlement, they're certainly empowered to accept that settlement as a settling of all claims. Both states allow for negotiation of child support. Now, the court's not bound to accept it, but if they find that it's in the best interest of the child, they're allowed to accept that settlement number. And so I think it's an interesting.
So
Yes.
I just want to make sure I understand what you're
Yes,
saying.
I understand.
So once that $100,000 gets entered, Kansas is powerless to say, no, really the number is 150.
Yes, under UIFSA, I would say because of res judicata, they can't revisit. Just like and I think the way to think about it is if a Kansas court had said, we're settling all issues for it started out with 150,000. We're settling all issues for 100,000. We're not going to get into the issue of whether or not private school tuition was paid. We're not going to revisit any of these issues. This is the amount. Both parties sign on as a settlement. Then I think in Kansas you couldn't revisit that issue and say, well, now I've decided that I didn't like that deal. I want to go back for more. Essentially, I want to have that interest applied to it now. And so
I think that's true if it was clear that there had been a settlement, a waiver of that interest. I'm not sure that the record establishes that there was necessarily a foregoing of the interest. The journal entry seems to be silent about prejudgment interest.
And I agree with that, which is why I believe that what should have happened is the case should have been dealt with in Texas.
Why? Why?
Because
if the Texas court is saying what we are dealing here with is the amount of arrearage and post-judgment interest, and that's all the journal entry addresses, why isn't the issue of interest still alive in Kansas?
Because because Texas is empowered through UIFSA to deal with this issue as though they are a Kansas court.
They declined to do so. The prayer asked for it.
Yes.
But the journal entry, the final journal entry is silent. It says this journal entry addresses, whatever the word is, unpaid child support and any balance owed.
Yes, Your Honor, and I think the important point is that they're silent on it. We don't know, because both parties opted not to do any fact-finding into why that occurred, we have no explanation for why Texas made the ruling they did. But just like we have, but we also, there's no reason for Kansas to believe they made an error on that count. It may have been perfectly valid. It may have been an error. The Court of Appeals found that even were it an error, under the statutory scheme, that still bars future revisiting of the issue, because Texas is the place to get into that. Texas had the testimony. All the parties are in Texas. They were empowered through UIFSA to handle the case. So, and again, it sets up, if we're not going to sort of follow through on the obligations of UIFSA, and, we're going to say anytime there's an amount in any state that varies from what could potentially have been awarded in Kansas, then Kansas needs to go revisit that. I mean, that, the one of the principles that res judicata is based on is that, the person against whom that claim was made is now not subject to, multiple instances of revisiting this issue. And I think that you're establishing a situation where that could basically happen endlessly. Anybody who goes into another state under UIFSA and gets a number that they just don't even agree with can come back and say, and again, maybe, having seen a number of child support orders from various places, it's somewhat rare that the entire rationale for why a settlement was entered or why a number was arrived at is broken down, and so I think there's just a situation of kind of this endless vulnerability to, so you have the issue of competing orders that the Court of Appeals brought up, and then from the perspective of the child support payer, you really are never in a position where, you can know that a claim has been settled, and then, so assuming you would go to another state and you would want to make a deal and say, all right, I can give you a lump sum of X dollars in exchange for me not pursuing some right that I have, well, then that deal can be accepted in another state, and you could return back to Kansas and say, well, I would like to revisit it again. And even if you win, it's more litigation, it's more travel cost. That's the principle that res judicata is there for, is to have one place settle this once, and UIFSA has set it up so that these child support issues can be done, in a multiplicity of states.
I'm really troubled, though, that we have a question of fact as to whether or not the Texas court even intended to have a judgment relating to interest. It sounds as if, at least it's disputed, that there was an open colloquy in court where all parties, including Mr. Jaycox, were alerted that interest had not been determined and that would be settled in Kansas. So I don't see how you can argue that this is some sort of a not giving full faith to the Texas judgment if the Texas court was saying this judgment does not address the issue of interest, prejudgment interest.
Perhaps I misunderstood, and I'm sorry, but that it is not undisputed fact, and nor was it even cross-examined or looked into or found on the record that the Texas court judge said come back to Kansas and seek interest. That's something that was never found as a fact.
That's what I'm saying, is we don't know that. And how can we, that's troubling that we would be making a ruling that this was a final judgment in Texas when even there's the possibility that the Texas court didn't see it as a final judgment.
Then I think I think there are probably two issues there. One is where does the burden lie in this? Like where is the where should we default and what assumption we should make? And the principle of comity, the principle of also full faith and credit, which was brought up by the Court of Appeals, allows, basically determines or says that we should assume that Texas did what they were supposed to do. There's no reason to believe that they did anything incorrectly. We have no, there's no statement within if they didn't want it to be a final judgment, the final judgment specifically says a final judgment for arrearages and interest. It says that in the final judgment. There was no second part that said, all right, this is just for arrearages. If you want interest, go back to Kansas. They're as you pointed out, they don't say anything on that point, and we should, just the principle of us trusting another state, which again, we signed UIFSA, and when our legislature basically ratified that statutory scheme, we did so with the idea that we would trust other signatories on this on this statutory scheme to obey our law as though it was us. And so so now we have this situation where we say, all right, under UWIFSA, you're empowered to go to another state and enforce child support, maybe. But we're going to keep our eye on it. And then if it's something we don't like or we're confused by, then bring it back to Kansas and we're going to review it all over again. That seems impractical. It seems like the solution to that would just be to say, well, we no longer approve of that provision of UWIFSA. We'll just keep everything in-house. And then, but the way that statute works now, Texas was empowered to make that decision, and we should trust that decision, and any errors that were made in Texas should be handled through the appellate procedure in Texas. And, Ms. Kane, the appellant, had all the opportunity in the world to appeal through that process as she was there the entire time. So,
What were the defenses that your client would have been able to raise in Texas to the Kansas judgment of X amount?
I believe he didn't raise any defenses. It was not in dispute that he owed that back amount. The question was whether or not, it's not necessarily a defense. I think and again, none of this was brought up in the record. I think what he would have said is, well, I should receive some credit for paying private school tuition over the course of these years. That was never formalized within the child support order. Now, obviously, in Kansas, and I don't know about Texas law, there would be no rule that said he had to be credited for that. I believe that would be up to the discretion of a judge. But the point is, this is a question that could involve future litigation. And for both parties to say, well, we'll forgo that future litigation to settle all matters here with a lump sum payment, that's a perfectly reasonable solution to that child support arrearage that is not. And again, this may be a semantic issue, but it's not a modification of the order. It's still an understanding that he owed X amount each month for this period of time. But in lieu of pursuing every cent and in lieu of seeking credit by other means, we'll just settle it for this lump sum.
So you're saying the settlement was as to future issues I might raise in Kansas to avoid paying additional child support?
Yes, it was. We'll settle, possibly complicated. I won't pursue possibly complicated litigation. I'll accept from the other side. I'll just accept this lump sum right now instead of trying to come up with, a payment structure that goes out over time. And again, I apologize because none of this was brought into facts and none of this was, read into the record. But part of the reason we did that is this would require testimony of Texas officials who were present. It would have, right? Because it's not just that we could get a record from the trial in Texas. There were negotiations that took place, and because that was so difficult and because that would have been arduous and expensive, that's why from our side of things we stipulated and said, well, we'll just have this argument on the law. But and again, I think you can broaden this case, which I don't think is entirely unique. Which is, in any time this happens in any other state, the person, clients, child support payers are going to face that choice. How much money do I spend to go hunt down people in whatever state this was enforcing child support in order to come back to Kansas to prove that what happened over there was legitimate? And that's why res judicata protects people from having to do that. And again, under UWIFSA, where it's almost that you are, that's promoting the idea that you can go to these other states to enforce child support. If on the one hand we're saying, yes, here's an easy process for you to go to another state and enforce child support, but on the other hand, that's going to leave you completely vulnerable then to doing it all over again back in Kansas, plus with the added task of trying to get whatever information you need from this other state in order to prove that was legitimate. I think that's a confusing and complicated process that, as the Court of Appeals pointed out, leads us right back to that ERISA situation where you have conflicting orders, and that was clearly untenable. So,
Do we have any further questions? Thank you, counsel.
thank you, Your Honor.
The first that I had ever heard that there was some suggestion of some settlement in Texas was when I got the supplemental brief filed in this court a couple of weeks ago. that is a fantasy. If they thought that there had been a settlement reached in Texas, I realize the Court of Appeals said because this was a motion and not a petition that they didn't have to affirmatively allege affirmative defenses, and so I lost on that by saying, hey, they didn't file an answer raising res judicata as an affirmative defense. But I can't imagine that they wouldn't have filed something in court saying, hey, wait a minute, we settled this in Texas. There was never any settlement, and that probably is the reason why the journal entry from Texas or the order from Texas, where it has Denise Kane's signature, it says approved only as to form. There's nothing in there that you can conclude that there was any settlement, that was a settlement. If there had been, then they would have raised that as soon as we filed our motion here and would have said, hey, you don't know anything more because they settled that.
Well, what happened in Texas? Was there a hearing, an adversarial hearing, in which both the state and Mr. Jaycox put on evidence, and he tried to offset some of this stuff, or what occurred?
Honestly, I don't know, because we got the court file, we got no transcripts. I don't know that there were any evidentiary hearings. Honestly, I rather doubt it. I know there were hearings because there isn't much in the way of evidence to present in the responding state. Basically, all you present is, wait a minute, here's some canceled checks that I haven't been given credit for. I've paid these. You can't relitigate the issue of how much you ought to pay. And that's clear that they can't do that in the responding state. And that's why we really don't need to know what happened in Texas. What we know is how much he ended up paying that as a result of the Texas order. The Texas court said you pay $1,000 a month and then you pay X number of dollars by such and such a date or you go to jail. And he paid some. And he clearly gets credit on the judgment from that. The only thing we need to do to determine how much he owes is compute the interest on this judgment and the accruals each month on the Kansas judgment and subtract what he's paid, and he owes the difference. And it doesn't matter really how Texas got to that. This would be, and every state has UIFSA. Every state was required to adopt it. So there's a lot of litigation on UIFSA. I have not found any case, and I'm assuming that Mr. Johnson hasn't either, I've not found any case in any state where a court has held that a responding state's decision can change the amount owed in the state that has continuing exclusive jurisdiction. This would be the first. If the Court of Appeals is affirmed, this would be an outlier. We'd be the only state in the union where that would recognize that a responding state can tell us how much is owed on our judgment. Most judges don't like out-of-state judges telling them how to run their court. That's the whole concept of continuing exclusive jurisdiction, not something we had under URISA. Under UIFSA, though, we don't have conflicting orders. We may have an incomplete order in Texas that doesn't reach the same amount that the computations up here do, but that doesn't change this. They can't change this order. All they can do is say, here's how much you got to pay, and if he pays it, then he gets credit for it.
Do we have any further questions of counsel?
Thank you.
Thank you. Thank you both for your arguments this morning. Court will take this matter under advisement. That concludes